Industrial Disputes Act 1947 talks about industrial disputes. So what exactly an industrial dispute is? We are going to talk about the definition of industrial dispute in this video. Let me share my screen with you. So let us start with the definition of industrial dispute under Industrial Dispute Act 1947. So definition of industrial dispute, I have divided the definition into certain parts. First part says industrial dispute refers to any dispute or difference between employers and employers and workmen, and it may be in between workmen and workmen. So let us understand this part of the definition with the help of the examples. So any difference or dispute between the employers and employers. So like for example, the employers, there are two employers in the market and they are having difference or dispute with respect to market competition, or they have already entered into a joint venture and they are having dispute or difference with respect to that joint venture, or they might have applied for any government project by way of bidding. So there might be again a difference between these two employers. So these are the examples where a dispute or difference is there in between employers and employers. Coming on to second category of disputes in between employers and workmen. So this is very common where the dispute is taking place in between the management at one side and the workmen at the other side. So it may be belonging to the issue of wages or working hours or workplace conditions. So these kind of disputes are very common, right? Regarding the third category, workmen and workmen, here the dispute might take place in between two trade unions which are existing in same company or in same organization. So they have difference of opinion or they might be having dispute among themselves in between the two trade unions I'm talking about. So this refers to dispute or difference in between the workmen and workmen. Okay. The second part of the definition talks about connection. So the dispute is connected with which of the following: employment or non-employment, terms of employment, and conditions of labor of any person. So now let us understand these connections with the help of our example again. So first says dispute may be connected with employment or non-employment. Here the definition basically signifies that the dispute can be in relation to employment or non-employment of any person. Like for example, a person should be employed in the organization or not. So it refers to the hiring decisions. It refers to the layoff decisions. It refers to the retrenchment decisions, right? Okay. Coming on to the terms of employment. So terms of employment, again, there's an agreement at the time of the employment in between the employee and the employer, right? So dispute might be in connection with those terms and conditions of employment, right? For example, it may be with respect to wages, it may be respect to benefits, or it may be with respect to leave entitlement, or the dispute may be with respect to any contractual obligation of the employer or the employee, right? Okay, coming on to third part, that is conditions of labor. So condition of labor here specifically relates to well-being of the workers, right? Where the condition of labor is in danger out of any compromise with the safety standards or any occupational hazards. So any accidental situations are there in the company or organization which may lead to adverse conditions for labor, right? So total working environment conditions must be safe and secure for the labor. So this basic part refers to connection of any industrial dispute with respect to well-being of any person, right? Okay, so this definition part of industrial dispute is over. But apart from it, section 2A, we must be aware about section 2A also, which has a certain reference to the definition of industrial dispute under this act. Okay, basically section 2A is nothing but it provides certain privileges to those people who fight with the employer on their own. Okay, no other person or no other trade union joins them in fighting for their rights whenever a situation arises with respect to their discharge, with respect to their dismissal, with respect to their retrenchment or termination. So here a single person is being discharged, dismissed or retrenched, or his services has been terminated by the employer, and if he wants to fight for himself alone without the help of any other worker or without the help of any trade union, then he has this right under the industrial dispute, and this single man dispute would also be referred to as industrial dispute under the ID Act only. No matter no other person is with him, no matter no other trade union is supporting his or her dispute. So वो अपने आप जाकर फाइट कर सकता है अपने राइट्स के लिए विदाउट वेटिंग फॉर एनी अदर पर्सन टू ज्वाइन, विदाउट वेटिंग फॉर एनी अदर ट्रेड यूनियन टू ज्वाइन हिज और टू ज्वाइन हिम और हर, राइट. सो फर्स्ट पार्ट ये बोलता है. तो एक ये प्रिविलेज दिया गया है, इंडिविजुअल अपने लेवल पर लड़ाई कर सकता है जब कौन कौन से केसेस हो, उसको डिस्चार्ज किया गया या डिसमिस किया गया, रिट्रेंच किया या टर्मिनेट कर दिया गया उसकी सर्विसेज को, राइट. सेकेंड पार्ट में भी इसी पर्सन को एक और प्रिविलेज दिया गया है, वेयर इन जहां पर कंसिलिएशन ऑफिसर में के पास केस चला गया है, एक इंसान, एक पर्सन डिस्चार्ज हो चुका है, एक पर्सन डिसमिस हुआ है या रिट्रेंच हुआ है या उसकी सर्विसेज को टर्मिनेट कर दिया गया है. तो ऐसा वर्कमैन अगर कंसिलिएशन ऑफिसर के पास केस चला गया है एंड आफ्टर द एक्सपायरी ऑफ द 45 days no response has been received from the conciliation officer with respect to such dispute, then this workman has the right to move directly to the labor court or tribunal for adjudication of this dispute. अदरवाइज इंडस्ट्रियल डिस्प्यूट में क्या है कि लेबर कोर्ट और ट्राइब्यूनल को जो मैटर जाते हैं वो गवर्नमेंट रेफर करती है. एप्रोप्रिएट गवर्नमेंट हैज अ राइट टू रेफर द केस फॉर एडजुडिकेशन टू लेबर कोर्ट और ट्राइब्यूनल्स, बट हियर द राइट हैज बीन गिवन टू दिस workman whose services has been terminated or he has been discharged, dismissed or retrenched by the employer. तो यहाँ पर भी उसको एक राइट दे दिया गया है कि आफ्टर द एक्सपायरी ऑफ द 45 days फ्रॉम द डेट ऑफ एप्लीकेशन टू कंसिलिएशन ऑफिसर. सो कंसिलिएशन ऑफिसर को केस मूव हो गया है, 45 days has been expired and no response has been received from the conciliation officer, then he has every right to move his case for adjudication towards labor court or tribunal for adjudication of the dispute. Is that clear? तो ये राइट दिया गया है उसको कि 45 दिन के बाद वो अपना केस लेबर कोर्ट और ट्राइब्यूनल में जाके लड़ सकता है. बट एक यहाँ पर एक लिमिटेशन पीरियड लगा दिया गया है कि ऐसे किसी वर्कमैन के पास कितना टाइम पीरियड है जब वो ये मैटर एडजुडिकेशन के लिए रेफर कर सकता है. दैट इज before the expiry of 3 years from the date of any such event. Any such event का मतलब है from the date of discharge, dismissal, retrenchment or termination of service as the case may be. तो 3 साल से पहले उसको ये एप्लीकेशन एडजुडिकेशन के लिए लगानी है, तभी पॉसिबल है, राइट. तो सेक्शन 2A का बहुत बड़ा रोल है विद रेफरेंस टू इंडस्ट्रियल डिस्प्यूट डेफिनेशन अंडर द आईडी एक्ट. तो ये हमें पता होना चाहिए. So that's it from my side. Thank you so much. नमस्कार दोस्तों. If you are preparing for UGC NET code 08, code 55 or code 17, then get in touch with Human Peritus. Human Peritus is having vast past experience of almost 14 to 15 years in teaching these subjects. With Human Peritus, you will not only get live classes, previous year questions and recorded sessions, but also the coverage of entire syllabus of these subjects. So visit our website www.humanperitus.com to get in touch with us.